Thank you. Welcome to Objection to the Form. This is Justin Humphries, and today I've got Ryan Bisplinghoff with us. He's a partner at McAngus, Goudelock Courie, and a good friend of mine, so thank you for coming on.
No, thanks, Justin. It's a pleasure to be here.
Today we're going to do a discussion for small businesses about workers' compensation laws and kind of do you need workers' compensation insurance, then kind of go briefly through the process and how it works out. Ryan's an expert in this area, a partner at a very well-respected defense firm, and I look forward to speaking with you about it.
Sounds good.
So kind of as an initial question, an initial inquiry, when does a small business need to make the step of getting workers' compensation insurance?
So in North Carolina, you have to have workers' compensation insurance if you have 3 or more employees, and so that is going to also include officers in a corporation, and that's where a lot of small businesses get in trouble, where they've got 1 or 2 named officers and only 1 key employee, and they think that they do not meet the requirements, and they actually do have 3 or more under the definition, and they don't get workers' comp when they in fact need it.
What are the consequences of not having that insurance, or what's the risk?
Yeah, so several years ago, there was no real risk in that situation, and they really didn't enforce it for these executive officers. However, the Industrial Commission, which is the administrative office in North Carolina that handles workers' compensation claims, started actively pursuing employers to make sure that they were complying with the statute. And so if they determine if they make a determination that you have 3 or more employees and you don't have workers' compensation insurance, you're going to be fined. The penalties can be $50 a day up until the time that you actually comply with the statute. So if you're operating for a year without workers' compensation insurance, you can do the math. It can be fairly significant.
Have you ever done one of those fine hearings at the Industrial Commission?
I have.
I've seen it's kind of it's not a pleasant process. You know, they tend to want to go through all your payroll records and want to see how many employees you had. And it's a pretty invasive situation.
Yeah, it is. They'll request that you have all of your payroll records, all of your tax returns. For the last one we had, I think that they were requesting 3 or 4 years of tax returns. So it can be very invasive. The good thing is you can negotiate with them if you are in one of those situations, and they will work with you on those penalties and those fines, but it can be laborious.
Yeah, it's interesting. Like I've only done a couple of these, but the experience I had with it, they seem to kind of dance on the line of can they go after a company's officers or owners in their personal capacity. I don't think it's really been played out, at least outside of the contempt context, but they would kind of hint around it, or that was kind of some of their negotiating posture.
Yeah, and they've recently, there's a new commissioner, there's a new there's a new chief commissioner at the Industrial Commission, and I think that they are working to change that process. For a while there, they were very aggressive, and they were threatening to go after individual officers and things of that nature. And I think that the legislature has, to whatever extent that they can, I think that they've, I don't think that they want them doing that, basically.
Yeah, that's probably a good thing, because I know that the overall goal behind what they were doing was good, of making sure that employers have insurance and that the employees are protected. But in a lot of situations, they were jeopardizing people's jobs by trying to come in and shut down small businesses with just huge fines. And so I'm glad to hear it's been lightened up a little bit.
Yeah, no, that's exactly right. And that was the debate. What are you trying to do here? Are you trying to punish these people, or are you just trying to get them in compliance and make sure that you're protecting the workers of North Carolina? And so I think that they have readjusted the way that they're doing that, and I think that they're more focused now on just making sure that folks comply when they need to comply.
One of the things I thought was interesting, it can also be a criminal charge, but for the most part, the DAs, it's pretty low on their list of what they're going after. And I've only had one client that received a criminal charge for this, and all it had to do was produce current policy to show the DA that no, now we have a comp policy, and that they weren't concerned with looking back and the time when it wasn't in place.
Yeah, and I think that the only time that, at least in my experience, there are several provisions in the North Carolina Workers' Compensation Act that are enforceable with criminal penalties. And in my experience, most of the district attorneys are not going to really pursue those unless there's just widespread fraud, or there's a large-scale effort to avoid having to do what you're supposed to do.
I didn't realize that was such a common thing. Like what other areas of the act are punishable by criminal sanctions?
So, for example, if you're an injured worker and you're out of work for a period of time and you're getting indemnity compensation and you fail to report to the insurance company that you're receiving wages from an alternative source, that can be punished by a misdemeanor and or a felony, depending on the amount of the benefits that you get. There are other criminal charges with regard to health insurance providers actually inappropriately billing injured workers when they're supposed to be billing the insurance companies as well. So there's a host of things that can be enforced criminally, but they're not typically done so unless there's a really big fraud.
Well, and kind of moving back, I guess, to the employer's perspective, I guess it's good to know that if you do have officers that you meet the threshold of having to have the insurance. It's my understanding that you can reduce your premiums though by kind of opting out of the insurance.
That's right. You have the ability, if you are an executive officer, you can opt out of coverage. So you're required to have coverage, but you don't have to cover yourself under the workers' compensation policy, which can effectively reduce your premium, because especially if you're a highly compensated executive, they can take that payroll out and you're only going to really need coverage for the folks that actually probably really need it if anybody's doing anything risky or in regard to their employment. Yeah. The other thing is, even if you don't properly get insurance, depending on the nature of your work, usually a policy is pretty cheap, especially if you only have 3 people and you're in a small startup. You're not going to be paying, and you're not in a risky field. It's not going to be a high premium.
It was kind of like in the earlier days of the firm, we kind of were in that area of 2 to 3 employees, and it's almost, you'd have to be an idiot to hurt yourself at a law firm, but it happens.
Lifting boxes and stuff like that. We get a lot of injuries where folks tripping in the office and all sorts of crazy things like that. So
so from that, I guess when you're in that kind of area of should you get it or should you not, and then you can always exclude yourself. Are there certain I thought I remembered something about minimums being in these like where they were going to base your premium off of like a certain, you can only go so low as far as your salary that they're calculating the premium from.
That may be the case. I'm not sure, Justin. I know that most of the time they're going to base it on your payroll. That's what they do. That's why you have lots of issues where, especially in the construction trades, folks will get workers' compensation insurance, but they will report to the insurance carrier that they only have 4 employees when they really have 10 or 15, but they're classifying the other 6 or 7 employees as independent contractors, and they're paying them on a 1099.
Is that what that ghost policy means? Or I've heard that term thrown around a lot.
Yeah, effectively. So you get a small policy saying you've only got a small number of workers, and then you really have all of these other workers, and you're paying them under a 1099. So we get involved in claims like that all the time, where there's some money in the construction trade that gets hurt. We speak with the insured, and they say, well, he wasn't an employee, he was an independent contractor. And I'm like, okay. But there's a whole series of factors that the courts are going to look at to actually determine if someone is an independent contractor. And I can tell you that just because you pay somebody on a 1099 and pay them cash does not mean that they're not going to be considered an employee.
I go through this every year on my they do get my audits of the workers' comp policy, and so they want to see your quarterly unemployment returns that show kind of what salary you paid out throughout the course of the year, and then we'll have various contractors that work with. Sometimes we get title abstracts or patent abstracts, or sometimes like we'll have mediator fees or other professional fees that kind of go in the 1099 category. And so then the auditor every time comes back and says, oh, we got to add this to your payroll, so now we got to bump up your premium. And I have to say no, and they say, well, and contractors count. And it's just a frustrating thing. I mean, it always ends up that these people aren't statutory employees, but we kind of go through that hassle every year. It's the worst.
Yeah, no, I mean, it is. And so, and from a white collar, quote unquote, white collar perspective, that's interesting. We don't really ever deal with it in that perspective. We're literally always dealing with, it's always the subcontractor, and it's, and most of the time they classify all of their laborers as quote unquote independent contractors, and they pay them on a 1099. but inevitably it goes back to control and things of that nature to determine whether or not they really are an employee. And what happens is somebody gets hurt, insurance company then does an audit, and they're going to seek back, they're going to ask for back owed premiums effectively, and if you don't pay it, then then you've got a situation where the insurance company has canceled their policy and now they're not insured at all.
So the way I understand it, the risk is when you're a general contractor, or you could be a subcontractor that has its own subs, and then somebody kind of under you in the chain gets injured and they don't have insurance. Is that the case, that's where it causes the problem for you?
Yeah, that's right. So in North Carolina, if you are a general contractor or a contractor and you contract with another company to perform a part of a job that you were hired to do, if you have to get a certificate of insurance from that contractor showing that they have workers' compensation insurance. And if you don't do that, and if they do not have workers' compensation insurance, then if their employees are hurt, you are going to be responsible for them. So before the job starts, under the law, you have to get a certificate of insurance, and you got to make sure that they have workers' compensation.
And I imagine with your certificate of insurance, it might be valid at the time that the insurance company issues it, but if you're on a monthly or quarterly premium situation, you don't pay your bill, it could be canceled.
That's right. So from the perspective of the contractor or the sub who is hiring the other company to perform work, you don't have any duty other than getting a certificate of insurance from them that shows that they have valid insurance. There are some arguments that you may not be protected if you should have known that they did not have insurance, or you somehow colluded with them to, defraud the insurance company or something like that. But generally speaking, if you hire a sub and they give you a certificate of insurance, and prior to that job working and prior to when you hired them, if they have insurance and you've got a valid certificate, you should be protected even if 30 days later they stop paying their premium and they get canceled prior to the accident, if you don't know about it. Now, if you become aware of the fact that their insurance has been canceled and you continue to allow them to work on the job, I don't think that you're going to be able to make that argument.
I mean, realistically, how would you become aware of something like that?
You typically would not, unless they tell you and you just tell them it's okay. Yeah, unless unless you're very close with them and you just tell them it's okay. The other thing that happens a lot, and I have to tell folks all the time, like, this doesn't count. What will happen is a lot of these operations, especially in the construction fields, these guys are running shoestring operations. And so they don't have any money until they work on a job and get paid at the end of the week or at the end of the second week, right? So they normally have to do a couple jobs to get money in the bank to go get insurance. And so we get clients all the time where one of the subs workers has been hurt and he's like, well, he told me he was going to get insurance. He just didn't have enough money. I'm like, well, just because he tells you he's going to get it, that doesn't satisfy the requirements. You actually have to get the certificate of insurance. So it happens all the time that on the first or second week of a job, somebody gets hurt and nobody's got insurance because they haven't been paid yet.
Yeah. Well, that's kind of interesting. And when you're dealing with the private end of workers' compensation insurance, meaning, or workers' comp defense, meaning there's no insurance in place, are the rules the same as if you're insured, or is there any additional compensation or less compensation if there's no insurance?
No, if you do not have insurance and you are found to be responsible for somebody's injuries, it can be extremely expensive because you have to pay the medical bills, which can, if the injury is severe, can rack up to the tens of thousands of dollars very quickly. You'll have to pay them their indemnity compensation, and there is no reprieve from that under the Act. Typically, unless you negotiate a resolution with them and their attorney.
In that situation, are the medical bills dollar for dollar the hospital or provider's charge, or do you still get the benefit of kind of the workers' comp rates for treatment?
You'll get the benefit of the fee schedule.
Gotcha. So that's kind of one of the frequent, kind of shifting gears a little bit. One of the frequent inquiries I get from some of our business clients will be, I'll get a call that somebody's been injured at the job, and always the first question is, should I make them get a drug test? And then the second question is kind of like, well, what do I do in this situation? So I guess if we kind of take them one at a time, how does the drug test process work for a worker that's been injured at the job?
So that can be tricky because you have to pay attention to federal ADA and then OSHA regulations and things of that nature. And there have been some OSHA regulations, and I'm not an expert on that. And there's some parameters around what you have to, whether or not you have to require somebody to get a drug test or whatnot. And so without taking into account those OSHA regulations, typically if you're made aware of somebody getting hurt, you should send them to an urgent care, and then you should, when you take them to the urgent care, you should indicate to the people at the urgent care that you want to get them drug tested, especially if you suspect that there may be, you think that they may be intoxicated.
And so you don't have to have any kind of employment agreement or any prior authorization for the employee to get drug tested in order to require that?
You can require it. Now, they don't have to do it. They don't have to go get drug. We get calls all the time where someone clearly was involved in an accident, and the carrier wants to know if I can deny the claim because they refuse to go get the drug test. Sometimes we do deny the claim for that, but that is not an affirmative defense to a compensable workers' compensation claim. And technically, if someone would have a good argument, if they said, I refuse to get a drug test, I think that they would have a good argument. I mean, I don't know that it's going to be hard to overcome that for a defense to a claim.
So yeah, and that's good to know, because I always thought that there was a requirement that you had to consent to a drug test if you injured yourself at the job and to go in and get treatment.
No, not in North Carolina. There is no provision in there that says that if you get hurt at work, you have to go give a drug test. Now, many employers have policies that if they refuse to go get a drug test, and they're terminated, and we deal with that all the time. Somebody gets hurt, they refuse to get a drug test, they're automatically terminated because of a policy that they have. Yeah. But that doesn't affect the compensability of the injury.
I see. And so in that context, I guess the reason why you'd want the drug test is that if you were able to demonstrate that the employee was impaired at the time of their injury, then I guess that would be an affirmative defense for the insurer.
That's right. So if at the time that somebody's injured, they are intoxicated or they are impaired to an appreciable extent, and that impairment was the proximate cause of the accident, you can deny the claim.
Because, like, for example, let's say something like reefer. It might be somebody that, that from what I understand, that can stay in your system maybe 6 to 8 weeks.
Yeah.
So, your drug test comes back that you had THC in your system. But that's not going to prove that the guy was high at the time of the incident, I would think.
Yeah. Now, marijuana, we get claims that are denied for positive marijuana tests all the time. That is very difficult to prevail on an intoxication defense, unless you also have coworkers who can say that when he picked him up in the work van, he smoked a joint on the way to the job, he smoked a joint at lunch. If you can have other witnesses that will tell you or can quantify the temporal nature of the drug use and the quantity of the drug use, then we can get a toxicologist to say that, based on the fact that coworker said that he smoked 2 joints at 8 in the morning and then 2 joints at 12, at 3, based on all these factors, was he therefore intoxicated?
So kind of on a related note, what if somebody is injured and they have a prescription for lawful medication, but it's something that could impair you, like a narcotic or something like that, and the lawful prescription they took kind of put them in a state that caused their accident?
So the way that the statute reads, it says that it's a prescription that they're not prescribed. So I think that if they take a prescription and you're able to, I don't know that you're going to be able to approve that defense in that case. But that begs the question. It just depends on the circumstance, I think.
And I guess kind of the last thought I had on that is, then let's say you get the guy that did some coke in the bathroom. He's at work, and then has an injury unrelated to his impairment, but he was impaired, and you can prove it. Does the impairment have to cause the incident, or is it?
Yeah, that's right. It's got to be a proximate cause. So we talk about, I don't know why, but we deal with these cases a lot with roofers. So if somebody does cocaine in the bathroom and they're standing on a piece of plywood on the roof and a 35-mile-an-hour gust of wind comes and blows that piece of plywood off, and they're properly tied off and everything, and they still get hurt, you're going to lose that case. But if the guy does a line of coke in the bathroom, gets on the roof, doesn't tie off, and makes an aggressive effort to jump from truss to truss or do something risky and then falls off, then you're going to win that case.
Does kind of your benefit of the doubt and error kind of impact that? Like for, because people do stupid stuff at work all the time and injure themselves, but it's my understanding that if the stupid thing they do is related to the injury, then it's compensable.
Yeah, so being stupid and doing something dumb at work is not a defense either. But if you can show that they were intoxicated, I have been able to successfully make that argument, and you're going to have to get a toxicologist. But you're going to have to get a toxicologist to testify regarding whatever substance they did and the effects of that substance on their mental capacity and risk-taking and things of that nature, and get a toxicologist to say that if you did this amount of substance, that it did, make him impaired, and that, a risky behavior is a sign, I guess, of being impaired by that substance.
One of the claims that I see a lot, and it can be, the place where it's most prevalent is landlord-tenant, but mold. Mold claims, in my opinion, are the worst. Like, I don't like dealing with it. A lot of times, people, it's looking for an excuse after the fact. They say, well, I didn't pay the rent. Oh, well, there was mold.
Yeah.
The mold is why I didn't pay, and they need to fix it. And I think that you could probably found, this is a pretty humid climate in southeastern North Carolina. There's probably many homes have mold in it to a certain extent. But what I've seen a little bit of is employees making comp claims as a result of mold exposure. Have you come across that?
Yeah, those cases are rare, but they do exist. And if an injured worker is able to prove certain things, they're able to prove if there is mold in the workplace. They call those sick building cases, and they get sick as a result of that mold, then their claim can be compensable. If their work placed them at a greater risk of the general public of developing whatever sickness, and they're able to prove that the mold in that building was a significant causal factor in that, then they can win. Those cases are tough for injured workers to win. They're also tough to defend because.
Yeah, I imagine there's a lot of science that would go into it, and then you'd say, well, what was it a abnormal level of mold in the building, or was it just kind of within a normal tolerance? Was it toxic mold, or what? I think there's like thousands of different spores of mold and different.
That's right, and where did they even work in remote proximity to that mold, and things of that nature. And in every mold case that I've ever gotten involved in, one person gets sick, one person claims there's mold, and you're going to have. You never have one person that works in for a company have a mold claim. You're going to have 4 or 5 because everybody else is going to start feeling sick, even if they're not claiming that they've been exposed.
I know we've tossed around the term causation a bunch, which kind of the simple way of putting it is what caused the underlying damage, or what's the root cause of the case. How does it work in workers' comp when there may be multiple factors that cause the same injury?
Yeah. That's a good question, because I think it's a common misperception that just because an injured worker develops pain while at work or experiences some sort of injury to their body while they are on the clock, that it's automatically compensable. So there has to be some accident or some interruption of their normal work routine, and then that interruption or the accident must cause a physically disabling injury. So if you've got an underlying, and you can prove medical causation in a variety of ways, but you have to get a doctor to either say that event was the acute cause or the direct cause of whatever injury that you have, or you have to get a doctor to say that event at work was a materially aggravating factor or it exacerbated an underlying condition. So in North Carolina, the work injury doesn't have to be the sole cause, but if it is materially aggravates or exacerbates something, then the employer can be responsible for it.
Yeah, and I mean, I would imagine there's, like you were talking about, like backs or things like that. I mean, I imagine you could take it as remote as, I've been working at a desk and my posture's poor and I've been kind of hunched over this computer for 30 years and my doctor told me that's not good for my back or something like that.
Yeah, I mean, you can have, so you've kind of got two statutes that deal with, or two types of claims you can have at work. You have the accident claim, which means, I fell out of my desk and hurt my shoulder. And then you can have the case that you just described, and that would be under the occupational disease, which are these chronic conditions, the mold and other chronic type conditions. So if you're able to show, and you're going to have a doctor show that basically your job placed you at a greater risk than the general public of developing whatever condition it is, and that your job and the way in your performance of your job was a significant causal factor in in developing that condition, then it would be compensable. Sitting at a desk, I think, is going to be a tough claim to prove because everybody in America does that all day long. But there are certain other types of jobs that may place somebody in an awkward posture or things of that nature where they may be able to prove that case.
Well, kind of getting back to the employer. Earlier, I think you were discussing your recommendations for if an employer gets a claim, and I think you were talking about send them to the urgent care. First of all, is there a distinction? Is there a benefit of an urgent care versus a hospital or ER or anything like that?
Well, number one, urgent care is cheaper. So you don't want to send them to the emergency room unless it's a situation where they're ambulatory and it's a very bad accident. You know that they're going to need some significant care. If it's a minor accident or something that, based on your discussion with them, does not appear to be very severe, I would always send them to the urgent care because it's just a lot cheaper. And you may not always, and you don't always have to file every accident with your insurance company if the initial medical treatment is less than $2,000. So let me backtrack. So if there is an injury and it's reported to you, you're going to want to interview, obviously, any witnesses. You're going to want to take a statement from the injured worker, and you're going to want to send them to medical treatment to document whatever they're saying. If the medical treatment is more than $2,000 or they're going to be out of work for more than 7 days, you're going to need to file a Form 19 to report that injury to your carrier. And so you fill out a Form 19. Typically, when you get workers' compensation insurance, you're going to get a notebook. It's going to have instructions in there as to basically how to file a claim. So you're going to want to, find that notebook, reach out to your insurance agent, or if you're a large employer, you have lots of claims, you're going to know who to contact at the insurance company to report that. But those are the first steps that you need to do.
Is it your responsibility as an employer to get the injured employee to the urgent care or to the medical provider, or is that the employee's choice whether to go?
No, you have no affirmative responsibility to provide them with care. But I think that that's what you should do to make sure that it's properly documented and to make sure that they're taken care of initially, because if you want to make sure that they get that initial care, because if not, things can get just complicated and nasty at the end. At the end of the day, if they don't go. Now, we have cases all the time where someone gets hurt, the employer offers to provide them with care, the employee refuses. They don't have to go, they refuse, and then all of a sudden a month later, we've got a situation where they're claiming all these injuries. And many times that is a good defense if they have refused to go to medical care at the initial outset.
How do you go about documenting that you offered care? I mean, would you suggest just go back to your desk and type out an email that says that you fell today, I offered you care, you said no, you said you were fine? Or should you have forms in your office that you make the employee sign confirming that they've refused treatment?
Yeah, typically I would have an incident report form, and if there's an incident, you should fill that out as to what the person who got hurt, whatever they say happened, write down what they say happened. Go talk to some witnesses, write down what the witnesses say happened. If you offer them medical care and if they refuse, I would document that. Then I would typically sit down and go over that with the injured worker and say, all right, this is our policy. We filled out an incident report. You're refusing to go to get medical treatment. Go ahead and sign saying you're refusing to get medical treatment, and then just put it away and file it. That way, if something, let's say that there's an issue a couple months later, you can go back and you can actually remember who all saw it, what they said, and what they did. Because trying to piece that puzzle together months later can be very difficult.
And I guess there's always the concern where it's something like, injury that could have happened as a result of a fall, or it could be a degenerative thing, or you can't really pinpoint exactly when it was. I guess that can work to your benefit as the employer if there's no immediacy in the care or treatment.
That's right. If they fall down and you ask them what happened and they tell you that their right shoulder was hurt, and then 3 months later they claim that they broke their left ankle, if you've documented actually what happened and the fact that they never mentioned anything about the ankle, that's a good defense going down the road.
Are there form banks for small businesses that they could sometimes you'll get a Staples and you'll see like a example purchase order or invoice or things like that. Are there form banks available for people that they can kind of have a go by incident report for workers' comp reporting?
I don't know if there are or not. I'm sure that there are some out there. I'm sure that they're like ADP and some of these places have it. Big broker shops may have it. And there may be through, I know many of the carriers will offer, like I said, they'll offer training to some of their insureds, and they'll have some of that information. But the information that you get from your workers' comp carrier usually is going to have, you either going to be able to log into some sort of portal, or you're going to have a notebook that is going to have a copy of that Form 19 form and things like that.
Yeah, I don't think, all I remember ever seeing is my premiums and then them trying to claim the title of abstractors and employee or something like that. That's really the only interaction I've had. But fortunately, we've managed to keep ourselves safe at the office and hadn't had any any injuries picking up the paper or loading the copier or anything like that.
Yeah.
What about with driving? So that's kind of an interesting thing. If you've got employees that are required to drive, for example, I guess that's probably the most dangerous thing you do at a law firm is maybe drive to deliver a document or to file something at the courthouse or something of that nature.
Yeah, so the driving cases and the kind of working from home cases we're seeing more and more of that because number one, a lot of people drive all over the place for work, and if they get hurt, that it could be compensable. So typically, if you're in a car and you're going to work or you're leaving work, then that's not going to be compensable. But if you're in a car and you're running an errand, so there's an exception to that rule. Like it's called the special errand rule. So if you're in the car and you're driving to the courthouse to file something and you're in a motor vehicle accident, you're going to be covered under workers' comp.
Yeah.
Unless you have deviated and decided that you got to make a courthouse run, but in the interim, you're going to go and see your son, go eat lunch with your son at school, and then you go back. So if you've deviated, then you may be outside the scope of your employment. It may not be.
Is that the frolic and detour?
That's right. Yeah. That's right. Yeah. So, there, and then there's called the traveling salesman exception, where that's the folks that you're just you wake up, you don't really go report to an office, you just wake up and you just make sales calls all day. Like pharmaceutical reps and things of that nature, or home health care aides. Many times the first place they go is going to be to their first visit for the day. And if they are given a car or they have a contractual right to that transportation, they're going to be covered basically from the moment they leave their house to the moment they get home. But there's all of those are very fact-specific circumstances that are going to require kind of a in-depth factual analysis so you can understand how that transportation has been provided to that employee.
Can you hedge against that? So if you're an employee and you get in an accident, and I guess it could even be your fault in the accident, but as long as you were doing work-related activities, you've got coverage.
Yeah, I mean, so the whole system is it's a no-fault system. So, I mean, you can be screwing off. I mean, horseplay is compensable. So you can have folks in the office running around, jumping around, playing, not really doing anything related to work, and somebody gets hurt, and it's going to be compensable. And same thing with driving. If you're on the phone and you're not paying attention and you run into somebody and you get hurt, you're still going to be covered under the Workers' Compensation Act. Now there are extreme examples of like, if you try to go take your car and jump a ramp or something. I mean, if you did something crazy in your car, that may not be covered. Likewise, if you try to jump out of the window or something like that, here that's probably not going to be covered. But in general, just because you are a bad driver or you're not paying attention, doesn't really matter for the employer's perspective.
Are there any tips that you would give employers as far as what you can do to mitigate your exposure in a workers' comp situation?
Yeah, I mean, the number one thing is to get somebody the medical treatment and pay for them to go to the medical provider, and get your insurance company notified as soon as possible. I mean, the worst cases that I see from an employer standpoint is they don't want to file a claim because they're worried about their premium going up. So they're going to cover medical bills for they're just going to pay for the medical out of pocket. So what happens is they're not savvy enough to know that the claim may not even be compensable because there are defenses, because they're just not going to know that stuff. So they don't really do an investigation on the claim. They just start sending somebody up to the doctor. They usually will rack up $4,000 or $5,000 in medical bills because they're not paying them under the fee schedule. They're just paying the invoices that they come in. They're not reduced at all. So they're paying all this money out of pocket. And then all of a sudden the person needs an MRI or some expensive procedure, but it's 3 months down the road. Then they report it to their insurance company.
Yeah.
Then the insurance company gets involved and is like, well, look, number one, you were paying too much for the medical bills. Number two, we could have denied the claim, but now we can't really do a proper investigation, etc.
So if you fail to report as the employer, can you jeopardize your coverage?
You're not going to jeopardize your coverage, but you just jeopardize your defenses. And if you're an employer and the employer and the insurance company are basically treated the same in these workers' compensation claims. So if the employer pays all this out-of-pocket stuff, and they basically can take action that will stop the insurance company from later denying the claim, because the courts will say, well, the employer treated it as compensable because they paid for all this stuff and they kept paying them wages.
And I guess why that matters to you if you're the employer is because your premium's going to go up the larger the carrier pays out on your claim.
That's right. It will affect your premium, but what happens is the employer will pay all this out-of-pocket stuff. Then they'll eventually file the claim with the insurance company, and then I'll get involved as the lawyer. And first thing they'll ask me is, was the insurance company going to reimburse me for the medical bills that I paid, and are they going to reimburse me for the wage continuation? And my answer is no. You should have reported it to them. They're not going to voluntarily reimburse you for that because you didn't. You're supposed to report it and you're supposed to do X, Y, and Z, and you did not do that.
What would your advice be to the employer that feels like an employee's made a disingenuous claim? Because that's a question I get commonly from employers. They'll say, well, Jim's laying up from work. He claims that this was some kind of back incident from work or something, but we don't believe him. This is his fifth claim. I know you got to be careful because you can end up with a retaliation claim if you fire someone or terminate them because of making an workers' compensation claim. But do you have to keep the employee employed that's kind of a habitual claimant, or you feel like they're being dishonest?
Well, I mean, you do have to be careful with RETA, and you can't fire somebody because they make a claim, and you can't fire somebody because you say that, because they say they're sick or something like that. But I mean, the biggest thing is most of the time bad employees don't become great employees. And so if you've got some of these issues, you need to start recording it and you need to start documenting it. And if they do file a claim and if they do report it to the insurance company, you need to make sure that you explain to the insurance company, hey, look, there's red flags on this thing. Y'all need to really investigate it. This guy's been out of work all these days for X, Y, and Z. You need to provide them with the information so they know that when they do their investigation.
Well, what about the situation where just you're a small employer and you need to replace that person's position because they're not available to do their job duties? Maybe they're legitimately injured. Can you let somebody go just on the basis of, hey, I had to bring on somebody full-time to replace you, and I'm not going to be able to bring you back on once you recover?
No, now again, just in workers' compensation, again, I don't want to jump into the ADA because I'm going to end up giving bad advice, but no, there's no requirement. I mean, North Carolina is an at-will employment state, so you can hire and fire at will. And so even if someone has filed a workers' compensation claim, if you have a good reason to fire them, you can do that. For example, someone may have a valid workers' compensation claim, but they refuse to undergo a drug test despite the fact that they know that they're supposed to do that. That happens all the time. If that's what the policy is, folks will terminate them for that. It may make the claim more expensive once somebody's terminated, but if you've got a good reason to terminate them, you can do that even if there is a workers' compensation claim.
Gotcha. That makes sense. And I guess, in that sort of situation, it's kind of, I mean, yeah, there's more to it than just the workers' comp end of it. But I get what you're saying as far as, just you can't, you don't want the claim itself to ever be a justification for something, for a termination or an employment decision.
Yeah, that's right. And you can, I mean, but you just need to treat the injured worker just like you would treat any other employee. And if you do that, and if you have documentation, then you should be good.
What's the deal? So what about make work situations? And as I understand make work, that's when you've got somebody that maybe, maybe they have a physical job, and because of an injury they sustained at work, they're on a lift restriction or something of that nature. And you say, well, you know what? I don't want to pay this employee just to stay at home, which I guess would be 2/3 their income. I'm going to bring them in and have them answer the phone, or something that's maybe not really a position, but you can still find something that has some kind of value to the company. Is that a problem to create a new position that maybe didn't otherwise exist to accommodate somebody's injury?
Yeah, no, so that's a good question. So in North Carolina, if somebody has gotten hurt and they've got work restrictions and they're not at MMI, which means maximum medical improvement. So in layman's terms, they're still treating. Basically, they've not healed. The doctor has not performed surgery and said that they're fine or declared them to be at maximum medical improvement. Let's just say they have temporary work restrictions following an injury. In North Carolina, you can create a position for them to work. It doesn't have to be what's quote unquote called a suitable position or suitable employment. So if you have a position and that you want them to do because you want to bring them back into the office and keep them engaged in the workforce, you certainly should offer that. There's a couple things that you've got to do to make sure that it's suitable. You're going to have to come up with a written job description. You're going to have to send that to the doctor. You're going to have to basically ask the doctor, hey, these are the restrictions that they have. This is the job that I've got for them to do. Can they physically do it? If the doctor says yes and signs off on it, then you can offer that position to the injured worker. But you've got to get the doctor to sign off on it.
Does the pay have to be the same as their prior job?
It does not. It does not.
So you could, I guess, in theory, you could take it, because the way I understand, when you're, I guess it's temporary total disability, if you're too disabled to work, your pay is maybe, is it 2/3 of what you would have gotten?
66 and 2/3. Yeah.
So if that's the case, then you could, as the employer, say, well, if I'm paying 66 and 2/3, I've got this new opportunity that you can do at 62 1/3% of your prior income. That, as long as the doctor approves it, then that's a feasible option.
That's right. The injured worker would be entitled to temporary partial disability benefits. So the way that typically works is, let's say somebody's working in the field in a skilled, let's say they're a surveyor in the field and they're getting paid $30 an hour, right? Let's say that they get hurt, but survey company's got a job in the office filing. They pay $12 for you to come in there and file. So it's 40 hours a week. You're sitting there filing all day, but you're making less from the employer than you were doing your surveying job. The insurance company is going to make up those wages. They're going to pay you temporary partial disability benefits.
And so is that 2/3 of the shortfall?
That's right. So you'll take their pre-injury wage and the difference between their return to work wage, get that number, and then you take 66 and 2/3 of that figure, and that's the temporary partial disability benefit that the insurance company is going to pay. But it's going to be lower. I mean, it's going to help if you're worried about your premium, the amount paid out on the claim. That's going to help. Plus, the reality of it is keeping workers engaged and keeping them in the workforce is going to be more helpful in the long term. There's all of these studies that show that the longer a worker is away from the job and the longer they are under quote unquote disability status, it's just harder and harder statistically to return them back to work. Yeah. So if you can keep them engaged, it's very helpful.
Well, it's kind of like almost like the gap in the resume thing. When you're looking for employment, kind of the longer you're out, the longer it takes to get back and to re-engage in the process.
That's right. I mean, and they become deconditioned, and I mean, there's lots of different things that make it, and they just lose. Eventually they just they lose whatever buy-in they had with the company, and they don't really care.
What would you say is the biggest issue that's litigated in workers' comp? Is it I can't go back to work, or is it whether or not I need this medical condition or this medical treatment, or is it that I'm permanently disabled because of my injury?
So in North Carolina, there's a lot of litigation surrounding, I guess, three things. One is just going to be compensability in general, because we still have a very viable, I guess, injury requirement, or accident requirement in our claims. I mean, you have got to show that there was this interruption of the work routine. You've got to show that you weren't doing your normal job. And so there's a lot of litigation with regard to just compensability in general. Then the next thing is going to be disability. There's lots of litigation over whether a job is suitable. Typically in the situation wherein they're at maximum medical improvement and they've gotten permanent work restrictions, and there's litigation over whether or not their pre-injury job is something that they can physically do. And then medical treatment disputes. Those are the three things where we see a lot, because in North Carolina, the employer and the carrier has the right to direct medical treatment. So if an injured worker gets hurt and they accept the claim, the insurance company has a right to tell the employee where they're going to go to the doctor at. And if they don't like that doctor, there's lots of issues with that.
Hey, how does that work? Because I'm familiar with the process where the injured employee can get a second opinion, but I guess what you're saying is that as far as who actually performs the treatment, that's going to be the worker or the insurer's call.
That's right. So they're going to get to pick who we call them the authorized treating provider. So typically the claims adjuster is going to, let's say it's a knee injury, they've gone to a Medac or an urgent care. Urgent care says, look, you're not getting any better. You need to go to an orthopedic provider. And the employer says, my cousin went to Dr. Smith in town. He's the best knee doctor. I want to go there. The workers' compensation carrier is typically going to say, well, that's nice, but I'm not going to send you to Dr. Smith. I'm going to send you to Dr. Brown. That's who's our approved doctor, and that's who we want you to go to.
And I guess they're really not retained experts. They're just treating in their normal. What would they do if workers' comp take that out of the picture? This is what I think.
Yeah, so they're not. I mean, this isn't even an expert situation. They're just going to pick who you get your treatment from, and if you don't like it, you have to file a motion. You have to show the industrial commission why you don't feel that you can treat with the workers' comp doctors. Now, you do have the right to there are two different second opinions that we deal with. And so the worker does have the right to request a comprehensive second opinion. So let's say that there's a situation wherein the employer sends you to Dr. Smith. You go to Dr. Smith, and for whatever reason, you're the injured worker, you don't like Dr. Smith, or you disagree with what he says, or Dr. Smith is recommending a complex surgery and you're not sure you want to undergo that without somebody else looking at you. You can request a comprehensive second opinion from the insurance company. They don't automatically have to provide you with that second opinion. They have the ability to, the statute says they may agree to that. And so you can have a conversation with them, and they don't have to agree to the doctor that you want. But there is a process for you to get that second opinion if you can show a good reason why. And you're going to be given a chance to negotiate on a provider that maybe both of you can deal with.
Is there exposure for the employer or insurance carrier for medical malpractice? If you select, or your insurance company selects your employee's carrier, and then your designated medical professional commits malpractice, is that on you or is that on the medical professional?
So if you are, I'm trying to give a good example. So yeah, if the workers' comp doctor pays for you to undergo medical treatment and there are complications as a result of that treatment, the workers' compensation carrier has to pay for that resultant injury. The courts have said that is going to be causally related to the workers' compensation claim. Now, just because you get workers' compensation benefits for that, it doesn't mean that you cannot file a medical malpractice claim against that third-party provider. But the workers' comp carrier will pay for those complications.
And I guess the final thing, kind of that I want to talk about for just briefly, is subrogation. And so that's the situation where the insurer or the employer pays for their employee's injury, but it could be that a third party caused the injury, but it was compensable because it happened at work. Are there any tips that you would recommend for an employer as far as how to position themselves for subrogation? Or does, if it's paid by the insurance company, does the employer have to participate in the subrogation case brought by the insurance company?
No, typically the employer is not going to be participating in that. I mean, especially if they have, unless they're a big self-insured or high retention, meaning that they're paying out a certain percentage of that loss. Let's just say you're a small mom and pop company. You've got a worker that's in a car, they're in a bad car accident, and your workers' compensation insurance pays for those bills. You don't have to participate in the subrogation. Now, you may be asked to participate in that third-party litigation in depositions and stuff like that, but there's nothing really you can do as an employer to assist with that. Just help your insurance, just help the workers' compensation carrier, just provide them with that information. And that workers' compensation carrier is going to typically put the third party on notice that they have a lien against any settlement that the injured worker may receive.
And I guess most of those times it's not really a huge burden because they could subpoena you anyway, and it's no greater obligation than could be imposed through other means besides that.
Yeah.
All right. Well, I appreciate your time. I guess the big takeaway, as I understand it, is one, you need to, if you're a small employer and you're on the cusp of whether you should have it or not, you should take a look at your officer situation and kind of make sure that you're not exposing yourself to penalties for not having insurance. That documentation's a key. As far as to get an accident report if something happens or an incident report, and make sure to offer treatment. And then second, I guess finally just take care of your folks and try to avoid situation. Don't make decisions based on workers' comp claims, because that can lead to something bad. Did I miss something? Or
No, I think that's it. That's right.
Well, I appreciate it. Thanks again for coming on. I appreciate your time.
No, thanks so much.